Hi, everyone, and welcome to a webinar on the blanket Stark Law waivers amid the current COVID-19 pandemic. My name is Kristen Lawrence, and I'm a healthcare associate at Porter Wright Morris & Arthur. Again, I'll be talking to you today generally about the Stark Law and then discussing the specific waivers that have been issued and how your practice may benefit from the use of the particular waivers. With that being said, I just want to preface this with saying that the information is accurate and current as of the date that the webinar has been recorded. But considering the speed with which many of these regulatory changes have been coming out, I would not be surprised if by the time that this webinar is published in the next few days that there is some additional guidance on the subject matter or related subject matter. For example, just really briefly, there's some talk of similar waivers to be issued for the anti-kickback statute, which is very similar to the Stark Law. However, I do want to get this information to you out as soon as possible so that you can begin providing services as necessary. So really briefly, what is the Stark Law? The Stark Law is formally known as the Physician Self-Referral Law. The law prohibits physicians from making referrals payable by Medicare or Medicaid for designated health services to an entity with which the physician or a physician's immediate family member has a financial relationship or interest, absent an exception. Generally, the government has an interest in eliminating fraud within the healthcare system via overbilling or underbilling or et cetera. And the Stark Law and a handful of other laws are aimed to prevent such fraud and abuse. So really quickly, I would like you all to just take a look at the bolded terms such as physician, referrals, designated health services. These are all terms that are defined within the statute. It's important to take note of these terms because if the provider is not a physician as defined by the Stark Law, or the services are not designated health services as defined by the Stark Law, then there's no Stark Law liability. It's also important to note that this is not an intent-based statute. It doesn't necessarily matter whether the physician intended to enter into an arrangement that violates the Stark Law, unlike the anti-kickback statute where intent is an element. The physician could still face civil penalties absent intent under the Stark Law. So I wanted to just set out the Stark exceptions here and over the next slide. Essentially, these are arrangements that would otherwise violate the Stark Law, but there is some value in the arrangement, so they're accepted from liability with some qualifications that make the arrangement low risk. So again, these are just some additional Stark Law exceptions. Common exceptions are the personal services arrangements, charitable contributions, non-monetary compensation, fair market value compensation that we see a lot of providers taking advantage of. So now I'll transition into the crux of this webinar, which is to discuss the waivers. As you can see here, the waivers waive certain direct financial relationships and referrals to ensure sufficient health care services during the pandemic. There are 4 requirements to use the waivers. The waivers must be in furtherance of COVID-related purposes, which I'll go into more detail on later in the webinar. Providers must act in good faith. The financial relationship must be protected by the permitted relationships, which I will also delve into shortly. And the government must not have otherwise determined the relationship prevents or creates fraud or abuse concerns. So what are the COVID-related purposes? Generally, a COVID-related purpose is one that's directly related to the diagnosis of a COVID patient or to secure the services of providers during the outbreak. So as you can see with these additional 4 defined COVID purposes, put another way, COVID-related purposes do not necessarily have to involve directly treating a COVID patient, but arranging for services to accommodate the treatment of COVID patients, to accommodate the surge of COVID patients, expanding the capacity of providers during the outbreak so that other patients may be treated are all considered COVID-related purposes. So this slide and the next several slides include the permitted relationships for which the waivers can be applied. Some of the waivers are self-explanatory and a little repetitive, but I want to go into detail on some of them and the actual application of the waiver. For example, one of the waivers allows for the compensation of personally performed services above or below fair market value. This waiver would allow entities to provide overtime or hazard pay to the physicians. The office space and equipment rental payments relationship, allows entities and physicians to refer office space or equipment back and forth at a rate below fair market value. Examples of how this waiver can be used is a hospital landlord giving physician rental rates at a lower rate or providing them with free equipment to accommodate patient surge. As you can see here, another permitted relationship allows the provision of additional incidental benefits to medical staff in excess of the $36 limit. Practically, this permits hospitals to offer things like child care services while staff are on hospital campus. A similar permitted relationship allows the provision of non-monetary compensation to physicians in excess of the $423 limit. So here, providers could use this waiver to provide equipment, meals, or training in excess of the normal amount in order to accommodate patient surge. So again, those last four relationships, I wanted to just kind of point out and give you examples of how they can be practically applied. The next few slides talk about some more obvious self-explanatory relationships, like the provision of low interest or interest-free loans here below, remuneration between an entity to a physician in the form of a loan by or to either party with an interest rate below fair market value or on terms that are unavailable from a third-party independent lender. We've also got the referrals by owners of physician-owned hospitals, referrals by owners of ambulatory surgery centers that temporarily convert to hospitals. And lastly, referrals by owners in home health agencies and referrals for in-office ancillary services at additional locations. I want to point out this second relationship where we're waiving in-writing requirements. So this waiver is going to remove the in-writing requirement under applicable Stark law exceptions, provided all other requirements of the exception are satisfied. So when you go through all these permitted relationships and the Stark relationships in general that may not be permitted relationships under the new rules, they will almost always include a writing requirement. Those have now been waived. So I do just want to caution you all once again that these waivers can only be used for COVID-related purposes. I would encourage you all to make sure that these waivers are only being used for COVID-related purposes as outlined earlier in the webinar. These are also blanket waivers, so there's no need to necessarily apply for the waivers. However, any party intending to take advantage of the waivers is encouraged to document their use of the waivers. Because again, one of the four requirements is that the government could determine that the waiver is not being applied for a COVID-related purpose. I also want to remind you again that the regulatory changes are ongoing and the information here is current as of the date this webinar was recorded. I want to thank you all for making it to the end of the webinar. I hope that you found the information helpful and that you're able to begin using the waivers as necessary to assist your practice during the pandemic. I welcome any questions on the subject of this webinar and any other questions that you may have going forward. You can contact me using the information that you can see on this slide, and please also feel free to contact my colleague, John Carney, the partner at the Porter Wright office here in Columbus and the firm's healthcare practice group leader. Thanks again for your time.